In this training module, I'm going to show you how to approach a typical patent specification. This includes understanding and drafting various parts of the patent specification according to my typical approach. By the end of this training module, you should be ready to draft several sections of the specification for your own provisional patent application. Let's get started. Before we get into the details of the different parts of a patent specification, I want to go over just a couple rules that apply to the patent specifications. You don't need to memorize these, but they'll be good information as you get started, keeping in mind some of these requirements. So for a provisional application, the provisional application for a patent shall include a specification as prescribed by Section 112A and a drawing as prescribed by Section 113. Now we've already looked at the patent drawings and you've created your patent drawings already for your invention. So we don't need to look at that any further. I've gone through the requirements that you need to know about. Section 112A is one section of the code that we're going to look at for your patent specification. But we're also going to get into the other sections eventually when we start talking about all of the details that need to go into a specification and the claims in an application. I just want you for now to know that this is the point where the laws of the United States actually require that a specification be provided as part of your application. The drawings are also required, as we've mentioned before, if they're necessary for the understanding of the invention. So if you look in the manual provided to patent examiners that's available on the USPTO website, it's called the MPEP. So based on the laws that are established by the United States, the administrative offices in charge of the U.S. Patent and Trademark Office then establish a bunch of regulations or rules that they also can enforce on top of the laws. And these regulations are all outlined and described and explained in some detail in the MPEP. Part of the MPEP, one of the chapters, talks about the patent specification, and it outlines the different parts of the patent specification that's required for a non-provisional patent application. Now again, that's for a non-provisional patent application, not for a provisional patent application. The same things that are required in a non-provisional are not necessarily required in a provisional. As you saw on the previous slide, a specification is required, but there are no regulations that require these certain specification sections to be included. However, they are either required or highly recommended in the regulations for a non-provisional utility patent application. And the order is really simple. The title, a cross-reference, which refers to any other related patent applications that you want your patent application to be tied to somehow. It gives a background section where you describe the prior art, which we've gone over. It gives a summary section, which is really just an introduction to your invention. It gives a brief description, which is the brief description of the drawings or the illustrations or the figures that are included in your application. That's different from the summary section, which is really a brief description of your invention. But the brief description section is the brief description of the drawings that you're including in your invention. And then you have a detailed description of those drawings, or some people call it a detailed description of the invention. It's really supposed to be a detailed description of the drawings themselves. It's really the substantive section where you put all the details in that you want to cover and get claim scope potentially or protection for your invention. Next, you'd put in claims. This is where you put the legal boundaries of your invention and you describe exactly what your invention is and where you want to protect. And then, like a technical paper might have, you put in an abstract, which is really just another version of the summary in a lot of instances that can be searched or printed on the front of the patent application or the front of the issued patent. This is the order that the Patent Office suggests that you put these sections into your patent application. I always end up with these sections, if they're applicable, in my patent application in this order. However, I usually don't draft these sections in this order. I draft them in a different order, and I'll explain exactly why I do that. Also, you don't need to have all these sections in a provisional patent application. So I'll show you which ones are required and which ones are not required, but I would still include, and then which ones are not required and I would exclude. And we'll go through that here in the different modules coming up. So on the right of the screen, you'll see a list of all of the same sections that are listed on the left. However, I've rearranged them into a different order. This is the order that I almost always use when I draft my patent application. I think you'll see why when we get into it. So far, we've done the drawings already for your application. And so the first thing I start with is one of the easiest, which is a brief description of the drawings. I simply list out what goes into the drawings and what each drawing is about. And it's really brief. It's one sentence each. It's not long. And I'll show you a version of that here in just a minute. Next, I'd write a background, because that's really where you started probably in your invention. What was available to you? What were the problems that you were trying to solve? And why were you motivated to come up with a new invention in a field that might have a lot of other things already happening in it? That's the background of your invention. I'll then draft the title. Then, if there's a related patent application, I'll note that related patent application in my patent application. In a provisional application, this section is often omitted because you can't claim priority from your provisional back to any other patent applications. However, there may be some instances where you want to say that you have another provisional or a non-provisional patent application on a related topic, even though you're not trying to tie them together formally. However, if this is your first provisional patent application, you'll probably end up omitting this section because it won't be required or applicable. After that, before we get to the detailed description that goes through all of the details of your invention, I will often write the claims. In this workshop, we're going to rearrange the order of numbers 5 and 6, and we're actually going to do the detailed description first before we do the claims. But I wanted to let you know how I usually draft my applications. After writing the claims and the detailed description, we're going to go in and write the summary and the abstract. And these are really copies of each other, and they're best to do at the end because they'll be much easier to write after you've written out all the details. Let me show you now what I would include and what I would exclude in my provisional patent applications. And as I mentioned before, I put in a brief description, I put in a background, I put in the title, claims, and a detailed description. I will often omit the cross-reference and the summary and the abstract because they don't really add anything, and there's no legal significance to not including them in your patent application. I've also underlined the detailed description section because in reality, that is really the only required section of the entire specification for your application. You're required to explain to somebody how to make and use your invention so that somebody of ordinary skill in the same technology area could go and make and use it based on your explanation. If you meet that requirement in your specification or in the detailed description portion of your specification, then you satisfy the requirement fully and you don't have to include any other sections. They're not required formally or informally in the provisional patent applications. However, I would still consider including them at this stage because they're relatively easy to put together in terms of the brief description, background, and title. And in the case of the claims, I would put them in there for another reason that we'll go over in a different module. But in brief, they can add some value to your patent application if you decide in the future that you want to pursue patent rights in a foreign country. Okay, now that we've talked about the different sections that are either required or optional or recommended, we're going to talk about that section of code that we referenced earlier, and that is section 112. Section 112 actually has several paragraphs. Paragraph A is the one that we're going to focus on now, and then we'll get into some of the other paragraphs later. Section 112, paragraph A, talks about 3 requirements that every patent specification has to meet. And I've given a little acronym here, BED. They stand for Best Mode, Enablement, and Definiteness. And we'll go through each of those in a little bit of detail. Section 112A, as you can read, says the specification shall contain a written description of the invention and of the manner and process of making and using it in such full, clear, concise, and exact terms as to enable any person skilled in the art to which it pertains, or with which it is most nearly connected, to make and use the same, and shall set forth the best mode contemplated by the inventor or joint inventor of carrying out the invention. So let's review what each one of these means. Full, clear, concise, and exact terms. That really refers to definiteness at the bottom of my list. You have to be definite or clear as to what you're claiming. If you're ambiguous in the language you use, or you're not clear as to what is included in different variations of your invention, then you can run into problems of definiteness because your invention won't be explained fully and clearly and concisely and with exact terms. The next requirement is enablement in the middle of my list. It must enable any person skilled in the art to which it pertains to make and use the same invention. In other words, you need to teach somebody who's skilled in your same technology to make and use your invention. That doesn't mean they have the right to use it without your permission, but it means that you've taught them enough that if you were to give them permission, or really after your patent rights expire, they could go out and make and use it. Because after all, the patent rights that you're asking for from the government really are just a grant that recognizes that you've created something that's useful for the community, and the government wants to give you an incentive so that you'll share it with the community so that eventually the community can go out and make and use the same invention and build upon it, just as you've probably built upon other people's inventions in the past to come up with your invention today. The last requirement is the best mode. You must set forth the best mode contemplated. That means, what's the best way you've thought of to make your invention? You need to tell that to other people. In the past, it used to be that you could have your patent invalidated for not meeting any of these requirements. In fact, if you didn't meet the requirements, you didn't even have to get a patent issued. The patent office, if they could prove that you were not meeting the definiteness, enablement, and best mode requirements, wouldn't have to give you a patent. Or if they gave you a patent and an infringer then came back and showed that you weren't meeting the definiteness, enablement, or best mode requirements, they could then invalidate your patent on the same grounds. However, in recent years, with legal changes to these laws, Congress commented that the best mode really won't be enforced as a grounds for invalidating your patent application. So while it's a formal requirement that you're supposed to meet, they've actually taken away all of the consequences if you don't meet this requirement. So basically made it so it's pointless to have it in there, but they didn't bother removing it from the language of the statutes. In any case, you should point out what the best way is of making it. You don't need to emphasize it, but you need to include it in your patent application and make sure that it's in there somewhere so that you fulfill this requirement. Definiteness becomes a real issue when you start looking at the claims in a non-provisional patent application. We actually get down into the grammar and the language that we use in the claims to make sure it's clear and concise. And that's where some of the funny rules come in that make it sound like the patent is totally unreadable by normal people. The enablement is a little bit more ambiguous of a requirement. There are some tests that we could look at to see if a patent application enables the invention. However, what you'll really find is that the patent office and the patent examiners use the enablement sometimes, infrequently, to show that there's a problem with the application and to try to delay or avoid issuing a patent because of that reason. In terms of the best mode requirement, in all the years I've practiced, I don't think I've ever seen the patent office raise an issue with the best mode. They probably wouldn't know to raise it because they're not the inventor, and they would have to get inside your mind as the inventor to know whether or not you disclose the best way of doing it. So they don't use that as a reason to not grant a patent. However, in litigation, in an infringement proceeding, is when you might find that somebody comes across a document that says, hey, we really should make this invention this way, and then they'll determine that you didn't disclose that way in your patent application, and they'll use that as a backdoor to get around infringement or to even invalidate your patent so that they don't have to pay damages for having infringed it. So of all these requirements, what I want you to focus on is the definiteness one. I want you to be clear and concise and use exact terms in the way that you describe your application. And we'll talk about that more when we get into one of the next modules for the detailed description of the application. Lastly, I want to talk about patent profanity. This is a term that some patent attorneys use to refer to all the different ways that you could put language into your specification that you shouldn't be using. You shouldn't be using it because it can cause problems for you down the road, even though you didn't intend to make any problems in your patent application. These are things that I would avoid doing. That's why they're called profanity, right? You should avoid that. At least some people think so. So don't use these words or these types of words in your patent application if you can avoid it. I want you to take these types of words and use them as triggers when you're writing your own patent application and say, if I write this word, I either need to change it and get rid of it, or I need to soften the language a little bit, and we'll talk about how to do that. So anything that you put in your application as a requirement, it is required that this happens, or this piece is required or must be connected to this other piece, or this is essential for the invention to work. Those types of things you don't want to say. What you might say instead is, in some embodiments, and we'll talk about the word embodiments here just real briefly. Embodiments is a word you'll see a lot of patent attorneys use. It really just means one version of the invention or one variation of the invention, one physical implementation of the invention, and you might have many. So you'll see a lot of patent attorneys will use the word embodiment or embodiments a lot in their patent applications because they don't want to be limited to a single version. They want to say, oh, I've got different embodiments or different versions of my invention, and I want to protect all of them. So what you might say to get around this requirements type of language, you might say, well, in some embodiments, this is connected to that. However, in other embodiments, it could be connected in different ways to different pieces, and it's not required that these two are always connected to one another using only a certain type of connector. The next one is absolutisms. So anything where you say this absolutely must happen, right? This always happens, or this never happens, or there's zero chance of this happening, or it cannot do such and such. What you would say instead is, in one embodiment, it does this thing, as opposed to saying it always does it. Or in one embodiment, it does not do this thing, instead of saying it never does it. Or in one embodiment, it might be able to, or it might not be able to do this thing. Instead of it cannot. Cannot is often a trigger word that I would avoid. So avoid absolutisms. Also try to avoid characterizations of technology. We often won't use the word invention in our patent applications. And I know that sounds really weird. We have a lot of paranoia in what we do because we have very successful companies inventing things, commercializing them, taking them out to market, perhaps suing other people on them. And we don't want patent applications to come back to us, or issued patents even, in litigation to come back to us and say, hey, how come you wrote this word in here? How come you said my invention itself was ABC, when in fact ABC was just one version or one embodiment of my invention? So we want to be really careful, and we will usually say, in one version or one embodiment of the invention, it does such and such, as opposed to saying the invention itself does such and such. Prior art. You don't necessarily want to say, oh, there's a bunch of prior art out there. Anytime that you say that this exists or this is prior art to my invention, that can be used against you, kind of like the Miranda rights with the police. Anything you say can and will be used against you in a court of law, right? Same thing happens here. If you call something prior art, even if it wasn't prior art and you mistakenly called it that, you're going to be in a lot of trouble when the patent examiner comes back and says, you said it was prior art, and so I'm considering it to be prior art, and I'm rejecting your patent application on that. So I wouldn't necessarily go into describing what the prior art is, and I'll show you how to do that when we talk about the background section. Something that's common, something that's known, those are just other ways of saying this is prior art. So watch out for those words too. The next type of patent profanity is extremes. Anytime you have a range of motion or a range of temperatures or perhaps some type of range of operation of your invention, you could say we want to maximize the range, or we want to go to the minimum of the scale, or we want to optimize the efficiency of the invention. When you do that, there's a problem because it's really hard to tell what is the maximum, what is the minimum, or what is actually optimized compared to something that's not the maximum, minimum, or optimized. In some small cases, you might find that you can say these and they have a very specific meaning. But most of the time, they don't actually have a specific meaning. And what it really is an attempt by us as patent attorneys, or perhaps an attempt by you as an inventor, to just shorthand your description and say, well, we just want to maximize everything. We want to optimize how it works, without really knowing what optimize means. When you say those things, put in there what you actually mean. What does optimize mean? Well, it works faster. It works above a certain threshold. It changes something faster. It connects it longer. Whatever it is that optimize means, or whatever it is that maximize means, maximum probably doesn't mean that you have to be the absolute maximum on the scale, right? You might be good enough if you hit 98%. You might be good enough if you hit 95%. You might be good enough if you're above 80%. It really could depend on what it is that you're doing, but you probably don't actually need to hit the maximum or the minimum or the optimum of any invention in order to make it work. So what I would do when I come across inventors who like to use that language, I'll do one of two things. I'll ask them what it means, and I'll put in that language, or I'll put in a range of alternatives. I'll say in one embodiment, it might be maximized. In another embodiment, it reaches 95%. In another embodiment, it reaches 90%. In another embodiment, it doesn't drop below 70%. And we put in different variations to offset the fact that one version could hit the maximum, but other versions don't necessarily have to hit the maximum. The next type of patent profanity is relative importance. And this one's not as bad probably as the others, but I still try to avoid it. And so these are trigger words where I say, is there a different way I could describe what my invention does without trying to say that something is important or more important than something else, or it's got a higher contribution level, or it's positive or negative. We don't want to infer good or bad or judgmental types of things into our patent application. That doesn't help us. So we want to be very methodical and stoic about what we're describing. Is it urgent that something happens? Is it critical that something happens? Actually, it's probably not in most cases critical. Is it the way that the inventor would like it to happen? Sure. That doesn't mean that the only people you would ever want to stop from making your inventions are the ones who also consider it critical, right? You want to stop everybody who falls within a certain range of what you're doing. Whether or not they think it's critical or they treat it with the same level of importance shouldn't matter to you, as long as you can stop them from doing the same invention. Lastly, relative ambiguity. This one has become a really big hassle in the patent examination process. A lot of examiners are keying in on this and they're saying, you put this ambiguous language into your specification and I don't know what it means. And so we can't rely on it for anything. It's not definite. Referring back to the 112A requirements, it's not definite. It's not clear to me what it means. You said it's approximately 2. Well, I don't know if that means it's exactly 2.0 or if it's maybe 1.99 or if it's 2.5. What does approximate mean? You put that it's about 6 feet tall. Well, how far away could it be and still be about 6 feet tall? Sometimes it does this. Well, how frequently? Does it do it all the time? 50% of the time? 70% of the time? 30% of the time? What is the range that we're talking about? So whenever you put language in there that's relatively ambiguous because it uses a relative word without having an actual solid foundation to refer to, you know that you're probably going to run into a problem, especially if that language falls into the claims at some point in your non-provisional patent application. So don't use this type of language. Instead, give a variety of different ranges that it could be and express those ranges in different ways. Percentages, actual absolute values. Maybe a couple of them could be relative to something else, but for sure, make sure that you've got other things in there besides relative statements. And if you do put something in there that's substantially closed or substantially open or whatever it might be, make sure you define what that means. Substantially to the inventor means something. It means if it's substantially closed, that what? No water could get through, no air could get through, no dirt or dust particles could get through. What does substantially closed actually mean to you? Put that in there, describe it, and give some examples so that you're no longer falling into a problem with definiteness in your specification. So that's it. We've gone through some very high-level rules and guidelines and frameworks that I use when I draft a specification. I've also told you the order that I write my specification in and the different sections that I typically include and the ones that I exclude. So you should now be able to begin drafting some of the sections of your own patent specification, and we'll go through those in the next upcoming modules.